Hi, Sue.
Hi,
How are you?
I'm fine.
Good.
Hey, Sue.
Go ahead with your question.
I was at a service station in 2012, and I was pumping some gas. And as I paid for my gas, and I went out to get the nozzle from the pump, I have not pushed anything. The gas nozzle just went crazy and exploded over me. It got in my eyes and my hair. And I ended up had to go to the hospital and a dermatologist, and I had hired an attorney. And before I hired an attorney, I called the company and wrote him. They told him what happened, and he sent me a $100 check and paid my hospital bill.
Okay.
And I got an attorney, and so the attorney telling me now I don't have a case.
Did he say why, Sue?
Why?
Mm-hmm.
Yes, he said, I didn't get hurt or anything. And I asked him, why did he take the case? And he told me when I showed him the $100 that the man had sent me before I hired him, he said, no, we're going to send this back. This is not right. And he did. He wrote it up, and he mailed everything back to the man, and he just letting it linger on. And so he said, if he represent me, he going to charge me about an hour or something like $1,000 an hour. And he said that's the only way he would represent me.
John, your thoughts?
Well, first of all, I hope it didn't happen in January of 2012, because you have 2 years from the date that it happened in order to bring any kind of action. I'm talking about filed in court. So if it happened beyond that period of time, you still may have time. My suggestion is, if you're not happy with your lawyer, what your lawyer is telling you, there are a lot of lawyers, so go see another lawyer. Discharge a lawyer you have and go get some advice. You potentially have a claim if the gas pump was faulty, and the proprietor, the owner of the gas station, either knew it was faulty or should have known it was faulty, then you may very well have a claim. That's the basis of premises liability, that the owner's knowledge of the hazard is greater than your knowledge. So my suggestion is go see another lawyer pretty quick.
Yes.
And is that premise, PJ, or does it go into product?
That's premises, but what John said is correct. If they knew it was not working appropriately or should have known that, that's on them. If they didn't have any of that knowledge, but it malfunctioned because it was defectively designed or manufactured, that's on the company that built it or designed it.
Okay.
And we've had shows on product liability before. Those are very expensive, and fortunately, it doesn't sound like Sue was hurt very badly.
Right.
In all likelihood, it wouldn't be economically feasible to pursue, because you had to spend tens of thousands of dollars to pursue it. And if she got a $100 hospital bill or whatever her hospital bill was, fortunately, she didn't get hurt that badly.
And it's almost like medical mal, BJ, because they're very intensive. I don't want to say hard to prove, but a little bit more time.
In the product cases, right.
Yeah.
The product cases are very, very expensive, and you always have to have experts, and you always have a very well-funded defendant who will litigate the fool out of it.
Okay.
And you'll find yourself going all over the country taking depositions and making your case, which you can do.
Okay.
But like I said, it's going to cost a lot of money, and you only want to invest that time and money if the case has got substantial value.
All right.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by